Hi, everyone. This is Simon Brady, founder and principal of Anglia Advisors. Today, I want to talk to Michael Salazar, head of advisor solutions at Trust and Will. And we're going to talk about the service that I can offer to clients in the field of estate planning. Hi, Michael. How are you?
Hey, I'm doing great. Super excited to be here to talk about Trust and Will and help your clients learn a little bit more about how it might be an option for them to create an estate plan.
Great. Well, just so everybody knows, I have had some clients go through this process, and during the course of that, some common questions have come up. And what I'd like to do in this recording is to put those questions to Michael, so that the clients watching this can get a sense of what the process looks like. So. Trust and Will offers two different plans, Michael. There's a will-based plan and a trust-based plan. And these are priced differently, and there are different levels of input required for these. Can you just explain a little bit who would want the trust-based plan, who'd want the will-based plan, and just a little bit of background? What is a trust anyway?
Yeah, of course. So our trust-based plan and our will-based plans are different versions of a comprehensive estate plan that a client can purchase. So a trust-based plan is going to include irrevocable trust, the schedule of assets, certification of trust, and then all of the documents that are included within the will-based plan. So no need to purchase both of them. You'll only purchase whichever one's the right plan for you. So both a will and a trust are different ways that you can determine what's going to happen after you pass, primarily who is going to receive your assets. These are just done in different ways. So the first difference is when they go into effect. A will doesn't go into effect until the individual or the couple actually passes, but a trust is effective immediately upon signing it and funding it. So think of a will as a bit of a simpler document. A will is going to allow you to nominate a guardian for your minor children or even for pets if you're doing it through Trust and Will. You're going to be able to decide where your assets go and who you want those assets to be passed along to. You can also include your wishes for final arrangements, what is going to happen to your body if you pass, and then also any specific wishes for memorial services, specific wishes for a funeral service, anything like that. A trust is going to be a little bit more complex, but it does provide added benefits. So, of course, you will be able to, decide where your assets go, but you're also going to be able to have greater control over how and when your assets are distributed. So instead of it being, this entire account is passed on to Joe at the age of, is passed on to Joe when you pass, it's rather, I want this account to be passed to Joe. I want him to receive 25% of this account at the age of 30. I want him to receive 25% of this account at the age of 35. And I want him to receive the rest of it when he turns 40. So it can really give you more control over how that account or that asset is distributed.
Okay, and thank you. And one other aspect is probate that comes into this choice. Can you explain a little bit about what probate is and how it's handled differently between the two plan types?
Yeah, exactly. So probate is a term that comes up pretty often around estate planning. It's going to be the process of actually administering a deceased person's estate. So what that means is, the actual judicial process of validating the will to ensure that it's legally binding. So for context, if you have a trust, that's going to avoid the process of going through probate. So that's going to keep your assets private. The court isn't going to have any control over how your assets are distributed. You're going to avoid that 2 to 7% that is typically taxed from your estate from having to go through probate. So a trust is really how to avoid this entire process. If you just have a will, you didn't set up a trust, your estate is going to go through probate. It will be settled with the court. What you're going to do is, like I said, validate the will, ensure it's legally binding, take inventory of your assets, really get a better idea of what's included in your estate. They're going to pay off your debts and taxes. That is done with help from the executor that you assign, the executor of your estate when you create your will. And then they're going to distribute the remaining assets after debts and taxes are paid off to any beneficiaries. So to the people you want those accounts or those assets to be passed along to. So probate is a process that, will leave your estate subject to tax. And then also, it can be a pretty drawn out process. It can also be a painful process for families in a time where they do need to heal. So if you want to avoid that entire process, creating a trust is going to be the best way to do that.
Okay, got it. And if you do create a trust, along with that comes the decision as to who is the trustee. Can you talk a little bit about the role of the trustee and what should I be thinking about when selecting somebody to be a trustee?
Yeah, 100%. So the simplest definition of a trustee is someone who is assigned to manage a trust assets. So think about somebody who is organized, who is a good communicator, and who is trustworthy. Someone that you are going to trust to act in your best interest and carry out your wishes when you are deceased. So in this scenario, choosing a close friend or a family member is a pretty common route. It's something that we see pretty often here at Trust and Will, but that can also come with potential drama, of course. So choosing someone very close to you will have the benefit of understanding your family dynamics, your personal life, really what your wishes actually were. But it can also, cause a bit of drama after you do pass. Before making someone your trustee, especially if they are someone close to you, like a friend or family member, you should absolutely have a conversation with them ahead of time to make sure that they're okay with taking on that task. A lot of advisors like to joke, nobody is really super excited to find out that they have been named the trustee because it is a task that carries a lot of weight and it is a big responsibility. But also in some ways, it is a bit of an honor to be able to act as someone's trustee and ensure that their legacy is carried out the way that they intended.
Another role that you have to make a decision on, actually whether you have a trust or a will, would be guardians for minor children. And what are some considerations that you should take into account when choosing guardians? I mean, obviously, a married couple, if one of them passes, in most cases, the surviving spouse is the guardian. But we're talking about a situation where something catastrophic happens to both parents simultaneously or in quick succession, and somebody else is put in the position of bringing up minor children. What do you need to think about when picking a guardian?
Yeah, absolutely. So heaven forbid a situation like this does happen, but we do want your clients to be prepared, if something like this were to occur. So when considering a guardian, it's going to be who is responsible for taking care of your minor children if you were to pass. It's going to be something your clients maybe have thought about if they do have children, probably more likely to have thought about it than who would be a trustee. But it's going to be, sort of similar characteristics, right? Somebody close to you, either a close friend, family member, whether it's the child's grandparents, aunt, uncle, or a close friend that you do really trust. Trustworthiness. I would also say, organized, someone that maybe has children or has raised children themselves, and would be willing to take on that task to, really see your children all the way through and make sure that they are raised the way that you want them to be raised. Again, similar to the trustee, it's definitely a conversation you want to have with someone ahead of time. You don't want it to be a surprise.
Spring that on someone.
Exactly. When you're listed as the guardian for your minor children. So definitely have a conversation with them. Say, hey, it's unlikely that it will happen, but in the event of an accident, if we weren't around, would you be willing to be listed as the primary guardian for my child or for my children if I were to pass? And then the great thing about trust and will, you can assign a primary, you can also assign a backup, and so on, so that if someone either was not fit to serve as the guardian, or if they were no longer surviving, it would pass along to the next guardian.
Okay. Yeah, there's definitely some things to think about. I mean, some that I've seen is, perhaps you think your sister would be perfect, but you don't particularly like your sister's husband. You've got to bear in mind that if something happens to your sister, it's that husband who's bringing up your kids. And assigning guardians up the generational ladder is generally not encouraged. You were thinking about, 70-year-old people going to parent-teacher conferences. There's quite a lot to think about, but thank you for that. Before we start putting something together with trust and will, and we'll talk about this a little later, my role in the process, but there are certain things that that a client has to decide, and you touched on some of them before we start the actual process. So can we just quickly review? It's if you're going to use a trust, it's the trustee. You need to think about the guardians, as we've mentioned. You referred earlier to an executor. Can you just talk to that for a moment?
Yeah, exactly. So an executor is going to serve sort of the similar role as the trustee, but an executor is for someone who only has a will-based plan. So someone who has the last will and testament, they don't have a trust. That's the person who is going to be appointed to administer your estate according to the will, including the settlement of any debts and taxes, like we mentioned earlier during that probate process. So similar to the trustee, think about someone who is organized, who is a good communicator, who is trustworthy, someone who's going to act in your best interest. They can be a beneficiary of your estate, but they don't have to be. This person, please know that they will need to interact with attorneys, identify and control assets going through probate, and pay debts and taxes on your behalf. So, make sure it's someone who would feel comfortable and confident interacting with an attorney, having control over those assets. It's someone who's good with money, and I think organization and trust are also those characteristics that stand out.
It makes sense. They'd have to open up an estate bank account and oversee money coming in and going out of that. Okay, good. So if I do put some documents together through trust and will, presumably the early part of the process is an online experience. But in what format do I get the documents? And the question I always get asked, where should I keep them?
Yeah, absolutely. So to break down the trust and will experience a little bit, we serve as a platform to create and edit estate planning documents. So our process is going to take your clients through one question at a time. They'll only ever see one question at a time, so they don't feel overwhelmed. They don't feel like they're filling out some big, long, complicated form. Based on how they answer the questions, it's going to build a custom comprehensive plan for them. Based on how they answer it, it's going to add new questions, eliminate other questions, really build a custom comprehensive state-specific plan for them. Now, it takes the average member 20 to 30 minutes to do a will-based plan on our site. If they do it in one sitting, a trust-based plan is going to take on average 30 to 45 minutes if done in one sitting. And then they will have their plan all ready to go. Now, there are some next steps that need to be done offline. So the client can choose to either print their documents right away from Trust and Will, or they can wait 5 business days, receive a physical copy from us in a really nice custom folder. That's going to include instructions for notarization. And if they got a trust-based plan with us, it's also going to include a trust funding guide. So really specific instructions in terms of what needs to be done next, retailing accounts, making sure beneficiaries are up to date, doing any deed creation, deed transfer if necessary, making sure everything's properly set up under the trust. So really the important step for everybody is taking those documents and going to get them notarized to make sure that estate plan is legally binding. Once they have their estate plan completed, so documents created, notarized, and if they have a trust, their trust is funded, the next step is going to be storing those documents and notifying your loved ones of where they are located. So best practices are going to be a safe, dry place. Want to store them, think a filing cabinet, maybe a safe, probably not the best option though. Somewhere that you can store documents that you can also, tell your loved ones where they are located so that they can find the official legally binding version if you were to pass. And then it's also important to notify your loved ones. So if you have had a conversation about who your executor is going to be or who your trustee is going to be, and you want to be sure that they can find those, let them know. Say, hey, we just got our documents notarized. We're going to store them right here at this specific space in our home. When I pass, you're going to know exactly where to find them. And then you may want to notify some other parties as well. Like if you're close to your children, tell your children. If that trustee is no longer, alive when you do pass, your children will know where to find those documents and then how to move on to the next step of making sure your estate is set.
Great. And you touched there on, you said state specific. So does it matter to where in the United States my clients live?
No, so we do offer state-specific documents in all 50 states. So no matter where your clients are, it can be an option for them. Note the only place that we don't offer a plan, we don't offer a trust-based plan in Louisiana. Not sure if any of your clients are there, but that's the only place we don't offer a certain type of plan.
Okay, understood. This is great. So just a couple more points. What happens if I change my mind about something or someone after I've completed the plan? Or if somebody named in the documents predeceases me, or I get married, get divorced, move state. How do I make these changes? Well, first, do I need to make changes? And secondly, how do I make them if I do?
Yeah, awesome question. A lot of people want to create their estate plan and check that estate planning box and say, great, I've created it. Now I'm all good. I'm ready to die, right? When in reality, these documents are living, breathing things, and they need to change with your life, or they need to change as your life changes. So our platform, of course, is a more affordable, accessible option to create documents, but we also allow for your clients to edit their documents if they need to make a change. So after that purchase is made, your clients are going to have 1 year to make unlimited free updates to their estate plan. No cost associated. You can come online, make the necessary changes, print off a new copy of their documents. After that 1 year, it does go into a low-cost subscription service. Right now, it's $19 a year in order to make updates to a will-based plan. That will give your clients the ability to make unlimited updates from anywhere at any time digitally, and they can print off a new copy of their documents that way. So we do make it really easy. If something changed, like they wanted to change beneficiaries, maybe who they had assigned as their trustee passed away, and of course won't be able to fulfill that role anymore. They need to update that. Maybe they had a falling out with a close friend and they want to, disinherit them, make sure that they don't have any sort of assets if they were to pass. You can absolutely make those types of edits through our website.
Very good to know. And what if I have a question during the creation of the estate plan that me as or what if a client has a question that me as a financial advisor cannot answer because I'm not a lawyer. What are the options available to clients in that case?
Yeah, of course. So Education is incredibly important for us. So while your clients are going through this, they are going to be seeing definitions and explanations for why we're asking certain questions, so they can really gain a deeper understanding of what we're asking, how to answer it, and how the documents are really going to work for them. On top of that, the education we provide, your clients are going to have access to our member success team directly through our site via live chat, by phone, or by phone appointment 7 days a week. This team is trained by attorneys. Everyone's based in the United States, and they're completely invested in making sure your clients have the best possible experience on our site. So, think about questions about estate planning in general, questions about what our software is capable of, and if their situation fits the plans that we can create. Think about technical questions about the site, like how do I do this or that? And then even things like trust funding. If they had some clarifying questions there, they could get some assistance. The only thing that team cannot do is tell your clients what to do. So they can't provide your clients with direct legal advice. They can talk about best practices, point clients in the right direction, provide education, but they just can't tell the client, this is what you need to do.
Nor can I.
Exactly. So similar situation there. Now, if they do get a question asking for legal advice, they'll tell them right away, that's considered legal advice. We can't tell you what to do, but here's some information that might help you out. Now, if a client did feel the need to receive legal advice or wanted to sit down with an attorney over phone or by Zoom to go through the documents with an attorney, they could, depending on the state that they're in. So right now, we do offer live attorney support for an additional fee. I'm just going to list off the states that we currently offer. So California, Texas, New York, New Jersey, Pennsylvania, Ohio, Michigan, Missouri, and DC are where we currently offer live attorney support. We're working on expanding that right now based on population and demand. So when you see this video, go ahead and check out our website, trustmole.com, to find out where we currently offer attorney support. But that's going to be your client's opportunity to actually interact with an attorney, receive legal advice, review the documents. It's a very low use rate on our site. Most people feel like they get the help they need from that member success team, but we want to be able to provide that assistance to anyone that feels like they need it.
Michael, thank you so much for great answers to all those questions. I promise you, every single question I asked you is one that I have been asked. I have been asked by a client when going through this kind of process before.
Awesome. Well, I actually had a quick question for you. You mentioned you've had a couple of clients go through the process already. What has your involvement looked like, and what are you willing to do in order to make sure that your clients do take that next step and actually get set up with a plan here?
It's the nice thing, I think, or the feedback I've got from clients about what they've enjoyed about this process versus me sending them to an estate planning attorney with whom they're not familiar, is that the process is carried out with somebody with whom they're already very familiar, myself. And a lot of the information that comes up is information that I already have, because by the time we get to this stage in a relationship, we've gone through assets, we've gone through family, some family dynamics, marital status, kids, ages, all this sort of stuff. So we can jump forward in this process very quickly, rather than starting from scratch with a third party person who's going to say, well, are you married? Do you have kids? Where do you live? So just in a pure time-saving aspect, this is something that clients like. They're also familiar with me. They know me. We've done work together by this time. It does not involve meeting and developing a relationship with someone new. On a logistical way, I will have a conversation with them before we even get onto an onboarding process. We'll talk about some of the stuff that you've just mentioned. I will see to it that they've seen this video, for instance. So they will come into the process with a certain degree of knowledge about what it's going to entail. And the question process that you mentioned, where individual questions come up on a screen, I will be with them, guiding them on a screen share during that process. And I know you mentioned, and I've seen this before, you do have some very good explainers about vocabulary and terminology and everything else. But, the client will be with me as they answer those questions and can talk to me about it. And, some of the questions are quite intimate. What would you do in this particular circumstance, particularly the medical questions that do come up. So my role is to guide them through it, to give them set expectations for them. But to be honest, a lot of the heavy lifting is done by you guys. When those documents arrive, I've seen the instructions. They're very clear. They're very explicit. So my role is really kind of a background role, but simply to keep the client comfortable that I'm involved in the process and I'm there for some non-legal advice questions that they may have for me. So that's really my role, and I am thrilled to be involved with you guys. I think this is a service that's way overdue, and the clients I've had do this so far have been very, very happy. So thank you very much for that.
Awesome. Love to hear that feedback. We're looking forward to helping more of your clients get set up with an estate plan. We typically hear the barriers for why they haven't gotten it done yet are it's too expensive, it's too time consuming, it's too intimidating to sit down with an attorney. We're really trying to remove those barriers for your clients, give them a way to set up an estate plan that's more accessible and that's really going to work for them.
Congratulations. That's a very noble aspiration, and thanks for doing it. And thanks again for taking the time out to talk to me today. And this will be going out to a lot of my clients.
Awesome. Excited to see them come our way. And they can reach out to you directly if they have any questions and need some support. They can interact with that member success team. I know that you'll see it through to make sure that they've got a plan in place.
Thanks a lot, Michael. Take care.
Awesome.
Bye-bye.